Hi, Gary DeWall here, and this is Bridging the Week for January 6th through 10th, and today is January 13th, 2014. Good morning. Those darn red flags. The problem is that many red flags don't attract attention for three reasons. One, the staff reviewing them may not be sufficiently seasoned to recognize their significance or motivated to elevate the content to a superior. Two, in isolation, an individual red flag may not be so glaring, but only stands out boldly in conjunction with other red flags received across an organization. Unfortunately, firms, especially global firms, are not necessarily organized to ensure that all diverse red flags are captured, assimilated, and reviewed systematically. And three, even in isolation, an individual red flag may not stick out among a multitude of electronic communications or other data. However, once again, missed red flags have raised regulators' ire and contributed to criminal charges being filed against two entities. These relevant regulatory matters and more are all covered on this week's video version of Gary DeWaal's Bridging the Week and a very belated review of Walter Isaacson's 2011 biography of Steve Jobs and my reflections on lessons possibly learned for firms in the financial services industry is also included on the article version of my website too. So let's get started. Last week, criminal charges were filed against JP Morgan Chase Bank related to its provision of banking services to Bernard Madoff Investment Services from 1986 through 2008. Simultaneously, JP Morgan agreed to make a non-tax deductible payment of $1.7 billion and to other terms, including, quote, to continue its ongoing effort to implement and maintain an effective Bank Secrecy Act anti-money laundering compliance program, end of quote, to settle this matter. In return for this settlement, the U.S. Attorney agreed to deferred prosecution of the firm for 2 years related to this matter, after which, if the bank continues to comply with all terms, the U.S. Attorney's Office will endeavor to dismiss all charges. Concurrent with this action, the Office of the Comptroller of the Currency and the Financial Crimes Enforcement Network also announced settlement with the bank related to its handling of Madoff. As part of these settlements, the bank agreed to pay fines of $350 million to OCC and $461 million to FINCEN. The later fine, which is satisfied by the bank's forfeiture payment related to its criminal charges. According to court documents prepared by the U.S. Attorney's Office in New York City, Madoff's scheme operated, quote, the largest known Ponzi scheme in history, end of quote, from the early 1970s through Madoff's arrest during December 2008. The Ponzi scheme, quote, was conducted almost exclusively through a demand deposit account and other linked cash and brokerage accounts, end quote, maintained at JP Morgan during this time. Although at various times since the early 1990s, various JP Morgan employees worldwide observed suspicious conduct involving Madoff, the firm never filed a report regarding its suspicions with U.S. regulators, say the court documents. The firm did file such a report with UK regulators, however. Among other suspicious activities, during 2008, an analyst on the bank's London-based Equity Exotics desk wrote an email describing the bank's, quote, inability to validate Madoff's trading activity or even custody of assets, questions Madoff's odd choice of a small unknown accounting firm, and reported that the bank seemed to be relying on Madoff's integrity with little to verify that such reliance was well placed, end of quote. In its report to the United Kingdom's Serious Organized Crime Agency in the same year, the bank wrote that, quote, the investment performance achieved by the Madoff security funds is so consistently and significantly ahead of its peers year on year, even in the prevailing market conditions, as to appear too good to be true, meaning that it probably is. End of quote. Again, those red flags. Friday evening, in time for the January 13 effective date for certain new enhanced customer protection rules approved by the U.S. Commodity Futures Trading Commission last October 2013, the Commission's Division of Swap Dealer and Intermediary Oversight granted future Commission merchants temporary relief in connection with certain matters related to the receipt of customer funds in a single payment to one customer funds account type, you know, customer segregated funds, secured funds, or cleared swap funds, as well as permanent relief regarding certain matters related to their handling of customer funds in so-called Part 30 non-U.S. depositories. The details of these reliefs are a bit complicated, so check out the details on the article version on Bridging the Week on my website. Last week it was FINRA, and this week the U.S. Securities and Exchange Commission publicized its examination highlights for 2014 for each of the type of entities it oversees. For all entities, the SEC will, among other matters, seek to identify and prevent fraudulent or unethical behavior, assess how firms identify and mitigate conflicts of interest and various risks of their businesses, for example, legal, compliance, financial, and operational risks. 3, examine the governance and supervision of information technology systems, including operational capability and information security, as well as ability to deal with unexpected malfunctions and system outages. Consider unique issues with duly registered investment advisors and broker-dealers, for example, the influence of dual registrants regarding the type of account a customer may open, and ensure compliance with new laws and regulations. For broker-dealers, the SEC will also seek to assess firms' market access controls, internal controls generally, customer protection and capital rules compliance, and AML compliance, among other matters. For investment advisors and companies, the SEC, among other topics, will be reviewing the safety of assets and custody, conflicts of interest, and the accuracy and completeness of claims regarding investment objectives and performance. Aluminum producer Alcoa Inc. settled both criminal charges by the U.S. Department of Justice and civil charges by the U.S. SEC last week related to certain of its subsidiaries' alleged payment of bribes from 1989 to 2009 to Bahrain government offices to retain business. That's Bahrain government officials to retain business. Apparently, one of Alcoa's subsidiaries retained a consultant to help it negotiate long-term contracts with government officials. The relevant manager described the consultant as, quote-unquote, well-versed in the normal ways of Middle East business and an individual who, quote-unquote, will keep the various stakeholders happy. Another internal memorandum stated that, quote-unquote, the methodology of business in the Middle East is a complex web of interactions that are necessarily difficult to understand to disguise the payment of commissions. Both the U.S. Department of Justice and SEC consider these and other matters red flags that the company failed adequately to address. The SEC additionally claimed that Alcoa did not conduct adequate due diligence to assess the legitimacy of using a middleman in the first place. As part of its settlement, Alcoa will pay a criminal fine of $209 million US dollars and disgorge $175 US million. In agreeing to the settlement, the SEC noted that Alcoa made a voluntary disclosure of certain of these matters to both the U.S. Department of Justice and it during February 2008, and has undertaken extensive remedial action to enhance its anti-corruption policies and procedures. More red flags missed. And finally, ICE Futures filed with the CFTC on January 10th proposed amendments to its disciplinary rules to enable it, through its Vice President of Market Regulation, to authorize summary fines of up to $10,000 US dollars for certain infractions related to block trades, including failure to meet applicable minimum quantity requirements or for a participant not to meet eligible contract participant requirements, and failing timely to produce documents and other records requested by authorized exchange personnel or committees. These rule amendments are scheduled to be effective on January 28, 2014. Separately, ICE Clear Europe proposed to amend its list of permitted cover and limits on collateral to permit its clearing members to post certain Japanese government bonds, German Development Bank, so-called KfW bonds, and European Investment Bank notes to satisfy margin requirements. Well, that's it for this week's Gary DeWaal Bridging the Week. As always, there is more information in the article version of Bridging the Week, including this week my reflection on Walter Isaacson's Steve Jobs biography. Check it out on my website. Until next week, have a great week, and ciao!